Hi, Bill Henshaw here again with another update on my ongoing Oakland case. And to my surprise, it's ongoing. I mean, these people are so damn ignorant, they don't know that they've lost this case a hell of a long time ago. And they're going to pay a full price for it. But recent developments, and we've now had 3 hearings, 2 of which I've been present, and we have now 4 affidavits for each of these hearings, and we're going to destroy them on the counsel issue. And we're going to be filing a writ very soon in the California Supreme Court, or attempting to. If that fails, I've already got one ready for the 904 to the U.S. Supreme Court. But at the last hearing, and I did not know this, picture a courtroom where you're there and almost nobody can see the in custody people that are in the courtroom. Well, I couldn't, and therefore I assumed facts not in evidence, and that's on me, that my friend was at that hearing, but he was never there. That's when they called the case, I shot up like a cannon. I went over to the bailiff intending to announce my appearance and that I was there to testify, and especially on the unopposed writ of habeas corpus we have on file in this case that should have been heard a long time before this. Before I could do that, the new magistrate, they had a different one in that courtroom. Whether the old one was afraid of me, I don't know, because I've been communicating with her and suggesting all the problems that exist here, and all of a sudden she's not there at this hearing. He immediately appoints counsel for my friend, and I thought I heard my friend accept counsel, which is exactly what I want him to do now. And people, that's a 180 for me, because up until 2 months ago I would have said you're nuts. But when I finally figured it out, and I said counsel is what we want. The difference is our right to counsel doesn't come from the 14th War Amendment. And those of you who are not familiar with it, check out my video on that amendment. You'll begin to understand where I'm going here. But this right comes from all 6 articles of the Constitution, because all the unopposed issues that I raise, jurisdictional issues, have never been opposed and going on 5 decades. But these are issues that you need your counsel, to present for you. Because I gotta think about this. You go on an arraignment, and what do they tell you? You're too damn incompetent to appear pro se. Well, if we're incompetent, how can we possibly present these issues on the Constitution, which we were never instructed in the high school days when we were in the mandatory public education system? We have no way to be able to do it. That's the right to counsel we have, and there's a strong public interest in doing that, not to mention the fact that the counsel issue is going to virtually disassemble this government as quickly as it can be done, because that's the only thing they care about is your right to counsel. I've got them dead to rights on this one in a way they can't handle it. So in any case, my friend was not at this hearing. I didn't find it out until immediately after. If I had known that, I would have stopped the proceedings there and then and demanded to be heard. But they held a hearing, and he was in the courthouse, quote-unquote courthouse, but he was upstairs in the holding cell. Never made it to the courtroom, quote-unquote. And yet they appointed counsel, and this is the 3rd time they've reversed their position on the counsel issue by first finding him incompetent at the first hearing, which I wasn't at. The second time they reversed on a quote-unquote oral argument and found him competent. And now the last hearing, they reversed that and they found him incompetent. And all of this is oral motions, none of which I believe is anywhere on the record in this case. And this is the most important issue they think they have. And by the way, they tried to do this to me in my South Carolina case too, and I stopped them in the first 30 seconds because the judge said, well, we're going to have to, check your competency and see if you can appear pro se. And I stopped the proceedings. I said, wait a minute, now you're trying to bring the Barfetta case in here for Red v. California, Judge 422 U.S. 806, which doesn't apply because the 904s have ruled that the Bill of Rights doesn't apply to the states, Judge. Case is called Barron v. Baltimore, 7 Peters 243, and I said it just like that. But if I had known what I know now about counsel, I would have been back home, I'm pretty sure, in April, not in August. Because it took 2 months for them to figure out that I was quote-unquote competent. I had a couple of hearings before a very nice shrink that did her job. I thanked her for doing her job. We had 2 1-hour sessions, last joke. I was clearly competent. And they knew this from day one, because the reason I got jailed was that I filed a 150-page writ of habeas corpus, and anyone that can do that, you have to be confident to do what I did there. But the mistake they made going in was thinking I was some stupid schmuck off the street that downloaded something off the internet and filed it in this South Carolina case. And they found out only at that first appearance within the first 30 seconds. They must have been saying, oh my God, what have we gotten ourselves into here? They knew I wrote the writ, and they also had to know at that moment I was confident. So they never burdened me with counsel, but if I had known, it would have made a big difference then. Coming back to the Oakland case, this is what's going to win this case. And we have a hearing, by the way, on this non-statutory federal writ of habeas corpus that we did the impossible and we got it filed. And you'll learn how to do that with information on my documents. Send me an email, uwinnincourt@gmail.com. We figured out how to do it, because what you do is you go in there and you have the papers you want filed in your left hand, a federal criminal complaint in your right hand, and you tell them it's your choice. Federal criminal complaint in 20 and 36-point red letters says, federal criminal complaint, treason to the Constitution, United States versus your name here. And we're ready to go, and it will go to the U.S. Attorney General, and we will see what happens, because they're committing treason, and the Supreme Court says this. This is not me saying it here. Because they're, number one, aiding and abetting a court to exercise jurisdiction it does not have, while at one and the same time preventing it from exercising jurisdiction it does have by not filing our non-statutory federal writ of habeas corpus. The Supreme Court has said both of those things are treason to the Constitution. It comes out of a case called Cohen, C-O-H-E-N-S versus Virginia, 6 Wheaton 264 in 1819. And this excerpt is, I believe, on page 403 that they said this, and I believe them. And that's what we do, and I think that's where one of our big remedies is. We threaten these bastards, especially the lower level public servants. And we tell them up front that you better do what we want, because you know damn well that if we file suit, this is going to include a lot of your bosses, none of whom are going to take responsibility for telling you to do what you did here today. You're the one going to jail, not them. I think this is a big crack in the system, and they've been doing it to us for 150 years, divide and conquer. That may be about to end in this Oakland case. So the point being, the last statutory day they have, by their own admission, treating this as a state writ of habeas corpus. Don't ask me how they managed to do that. First page says non-statutory federal writ. They're treating it like a state statutory writ. Beats the hell out of me. Last day, November 12th, which is a Tuesday. And I will be there. We're trying to get this attorney to set a date. That's one thing we want. We want our friend in jail to order his agent to do is set an earlier time for this writ. Hell, we filed it, wouldn't you know, on 9/11. What a great day to be in court. And this writ should have been heard within a week. It's never even been acknowledged by the local dumbass, let alone opposed. So here we are again. What are they going to do? Even if we have a hearing, if they attempt to say anything, I'm going to stand up and tell them to sit down and shut up. They had their chance. They didn't do anything. This is exactly the way it's been for 4+ decades for me. And I have a documentary record to establish all of it. And that documentary record, people, is going to do for you what it's going to do for my friend in the Oakland case. It will get us before the 9-0 farts and get some questions answered as to why all this BS continues to happen. That's the whole point of exactly what I've dedicated my life to doing. And we're going to do it in the Oakland case. I'm pretty darn sure I can do it with yours. Although in most cases what happens is you hit them with 800 pages of my documents from day one. Case goes away. Charges either never get filed or they suddenly get dismissed in the interest of just us. And you don't see anything more about it. No trial, no cop, no nothing. So that's how the system works. And I'm really excited about this Oakland case. And this is very difficult for me. I'm a pathological pessimist. And I can't help but be optimistic here. This should speak volumes, people who don't know me. But, they have nowhere to go here. Because I've done my job, my friend in jail has done his job, and his mom outside of jail has done her job. And she's up to speed on some of these issues too. And she's been a big help. But the three of us working together, we're going to take it to them, and they have no idea. And what we keep hearing from the court, by the way, is, boy, people are making a lot of noise in this case. which I guess is what you call filing 775 pages against him in one day. And the last hearing I was in court, by the way, I moved over to the bailiffs to be prepared to go in and to take the witness stand. I learned later from my friends that were on the other side of the court that there were some attorneys still out there. They didn't call this case last, which is unusual. I guess it was a new judge, didn't know any better. So there were 4 or 5 attorneys there, and my friends told me, they looked at me and said, oh, there's that YouTube guy. Because a lot of people apparently have been watching my videos over there, and I hope in doing that they've actually learned something. Because these are issues they've never even imagined, let alone seen in any one of their courts before. So it's a big deal case over there, and I'm sure the dumbass office, they've been watching them. Probably the trial judge, quote unquote, has been watching videos. A lot of people have, trying to sort out what the hell it is I'm doing. And they're going to find out, if they don't know already, that I've got it down pat. I'm right, they're wrong. It's as simple as that. And the bottom line there, California, not a state. Everything collapses with that one fact alone. If it's not a state, what the hell is it? Whoa! So I'll have another update on my Oakland case the next time we do videos. I've got a hearing that should have been done at some point in time by the next 3 or 4 weeks. Or we could get the charges dismissed at any time. I'm continuing to assault these people with love letters. And I just sent one to the dumbass with my 17-page affidavit that's going to go to the 904s. And I said, if you really want this to happen, you go right ahead and keep this case active. If you don't, cut your losses. Now, dismiss charges, let the kid go home. This is not hard. A classroom full of 4th graders are going to understand this. Jeez. And law school graduates don't. You tell me. Thanks for watching. Remember to like my videos, subscribe, tell your friends, send me an email at youwinnincourt@gmail.com. Thanks.